9:30. Good morning, everybody. I'll introduce myself first. I'm Cindy Kaiser. I am with the California Victim Compensation Board. I am located in Sacramento, which is our headquarters, and telecommuting from home. So sometimes it's a little challenging with doing these things from home, which I'm sure you are all learning. And I will turn this over.
Great. Yeah, thanks everybody for joining the call today. I'm really excited for this training and to learn something while we're all in this unusual circumstance. So big thanks to Cindy Kaiser from the California Victim Compensation Board and to the NCTCC staff. I'm Executive Director for Northern California Tribal Court Coalition. And thanks to Cynthia Boschel for setting this training up from NCTCC, and also to Jake Swamp, our other NCTCC employee who's been working really hard over the past few years on our mobile application for victims of crime also. And also thanks to our partners from NIJC, National Indian Justice Center, Raquel Myers and Carol Oliva, particularly, I think they're on the line, and our app developer, Shuffle Labs, Will Marling might be on the line too. It's some anonymous callers on here. And our mobile app, there's more information. You can just search NCTCC mobile app, or maybe Jake or Cynthia can put the link in the chat, or I can find it. And that's an application that people can download and access information about victim rights, resources particular to our region in Northern California and tribal communities, and we're adding more CalVCB resources on there also. But this is part of our deliverables on our California Office of Emergency Services grant to develop the app and provide resources, especially, and it's pretty prescient during this time, or important while people might be stuck inside and wondering what their rights are. They can download the app and access that content offline. So without any further ado, and please put questions in the chat if you have them about NCTCC, but I do want to hand this over to Cindy.
Great, thank you,
Cynthia,
Stephanie,
I don't know if there's
and
anything more you wanted to say.
No, I'm good. Go ahead, Cindy. We're all here for you.
Oh, great. Thank you, and thank you so much for the opportunity for me to be able to share about our program. It is an amazing program, and I think you're going to find it's going to be really beneficial and a great resource for you when you're working with your clients out there. I've been with the program for about 10 years, and it's been very, very rewarding for me to be able to present to so many different agencies. It's really interesting when I find so many people have never heard of our program, and we've been around for over 50 years. So without further ado on that, I will get started. Hopefully you got the PowerPoint, and I sent out some other materials that I'll talk about, and then later you can print and use, and all of our materials are on our website as well, which is just victims, plural victims.ca.gov, which I have somewhere in this PowerPoint that you can refer back to. We do have legislation that is constantly getting introduced, and we did have 3 big pieces that were actually signed by the governor and effective January 1st, so I just want to touch on those really quickly. One has to do with pet sheltering, and the bill expands compensation under our relocation benefit for expenses to include the cost of temporary housing for any pets belonging to the victim upon immediate relocation. And this is huge because, especially with domestic violence, we know a lot of times victims won't leave their situation because they don't want to leave their pets behind. So this is going to be a great added benefit to our relocation. And then another one was human trafficking. So you can review the bills anytime. You can go on, I put the website down at the bottom of the slide. Anytime you want to go on and search for legislation or elaborate on ones that are passed by our program. And if you refer to our website, there is a page specifically for advocates that we try to keep all this information up to date for you. So the other bill, the AB 629, has to do with human trafficking, and it provides compensation equal to the loss of income or support that a victim incurs as a direct result of their deprivation of liberty during the crime of human trafficking. It does limit compensation to an amount not exceeding the value of the victim's labor as guaranteed under California law. So this is up to 40 hours per week, as well as no more than $10,000 per year, and it's for a maximum of 2 years. So we are required to adopt some guidelines before July 1st, which we are still in the process of doing, in order to determine how exactly we're going to calculate that loss. So we've only had a handful so far, and so it's kind of right now on a case-by-case basis. There is a form that can be completed should you be requesting income loss for your human trafficking victims. And then if the victim was a minor at the time that they filed the application, we'll distribute payment when they reach the age of 18 years old. The last one is the filing period. Our filing period prior to January 1st was 3 years from the date of the incident. We've increased that to 7 years from the date of the incident. So that opens it up for a lot more victims to be able to file with our program. So our program, like I said, we've been around for over 50 years. We were actually created back in 1965. We were the first in the country, so every state in the country has a compensation program. So by chance, if you're working with victims who were victimized outside of California, they would be eligible for those programs as well. And so we kind of like to look at ourselves as the national leader because we were the first in the country. We are the largest. And I do like to look at other programs, what they're doing, so we can make changes to our program if needed. Like I said, legislation is always being introduced, and we're always trying to enhance our benefits so that we're making sure that the victims are getting all of the resources through our program that we possibly can give. Our overall benefit is $70,000. And although some of the benefits within the program do have caps, which I will talk about, but the overall benefit is $70,000. And anytime you have a victim or a family member applying, they each fill out their own individual application. We have, in addition to headquarters, we have 21 county processing offices throughout the state, and 15 counties actually process directly at headquarters, and then we have 24 restitution programs throughout the state. So I wanted to add this map in for you because what it does, it's color coded, so it shows you the different counties and then the surrounding counties that, so for example, Alameda, you can see the color, and the counties that are that same color all file with Alameda. Now, having said that, and a victim can file anywhere they want. If they're in LA, they can file in Sacramento, or they can file in San Francisco. So it doesn't matter where they file, but we like to make sure that since everybody is spread throughout the state, that you know where these processing offices are. And then I really encourage, if you're going to be filing applications with a particular office, to, if you have the ability, to go to that office and get a little tour, meet the processors, build relationships with them, because when it comes time to ask questions, then you can ask directly with that processor and, like I said, start building those relationships. Our application and a lot of our documents do go out in languages other than English. And so right now, these languages that are more prominent, letters and things that go out, will go out in these languages. When you look at the application, up at the top, it says the asking for their preferred written and spoken language. So if that's identified, then we can send out documentation in that language. If it's a language that we don't have where we've translated already, we do work with outside agencies to make sure that we can communicate with those victims. And then how we are funded, so none of it's through taxpayer dollars. We're through restitution, fines, penalty assessments, and through federal funding as well. Penalty assessments would be if you've ever received a traffic ticket or should in the future, heaven forbid, you can take a little bit of comfort in knowing that when you pay that fine or you've already paid a fine, that a portion of that did come to our program. And I'm going to really quick shut my front door. I have a security door, but I hear that my gardeners are here today, and I'm in a gated community, and so they're going to be here for a while, and it gets pretty loud. So just give me 1 second really quick. Okay, thank you. Sorry about that. So that's where our funding comes from. Our fund is very secure, as you can probably identify with the fact that we are able to allow benefits of $70,000 per victim. And sometimes we'll make adjustments if we need to. And so that's why it's always a good idea to make sure you go onto our website to the advocate page, and you'll always see what's going on and different changes that are being made. We also made some changes more recently in years where anybody can now represent a victim on an application. And what that means is that you will, if you choose to represent your claimant, your victim, or their family member, that you kind of like our conduit between our program and the victim, wherein you help us get the information that's needed, and I'm going to talk a lot about that. So depending on what benefit they're looking for, we have certain types of information and documentation that they need. So by knowing this, it will really help streamline the application process. And so it's helping us keep in contact with them because, again, like domestic violence victims, sexual assault victims, a lot of times they're moving a lot, they change their phone number, and our program continuously sends out correspondence throughout the application process. So we want to make sure that they're getting that information, and that's where representing a victim is really beneficial. But having said that, we know that sometimes your caseloads might be such that you can't represent everybody, and that's okay. You can assist them with the application, but not actually represent them. And in that case, on our application, if you're familiar with it, Section 6 is where you would put in your information, your contact information, and then sign, and then that way we know that you're representing them. Otherwise, if you're just going to assist them with the application, then don't even fill out that section, and you can submit the application without that information. And at a later date, you can always represent somebody, or maybe you found out that they filed an application a year or 2 or 5 ago, and you want to now represent them. There's a form where they complete and you sign and just send in showing that you now want to represent. And that just means that, you know, you can call in anytime, get information on their application, where it is in the process, what bills we've paid out, how much is left in their fund to be paid, things like that. Now, when you're looking at our program, if you look at these 4 bullets, this is what we're looking at when we're determining eligibility. So was there a physical injury? So did that direct victim suffer an actual physical injury as a result of a crime? Or was there a threat of physical injury? And that could be verbally or with the use of a weapon. So somebody brandished a weapon in front of somebody. That would be a threat of physical injury, or even if they verbally made a threat of physical injury, that would qualify as well. Emotional injury in certain crimes, such as our sexual assault crimes, alone is sufficient. And then if someone is deceased as a result of one of our qualifying crimes. So the first half of this, I talk about the crimes that we cover, and then the second half is more about the benefits that we'll cover. So we have two types of victims that we cover, and this is what's great about California's compensation program, because some of the states, I mentioned every state has a program, some don't cover family members. In fact, I think Nevada does now, but at the time of the Route 91 festival shooting, and that was that took place in Las Vegas, I think it was 2.5 years ago now, 65% of those victims were from California. And those victims that resided in Nevada, they filed with their program, but their family members weren't eligible, where those that resided in California but attended and became victimized in Nevada were able to file with Nevada's program. And because they're a resident here, they were also able to file with our program, and their family members were eligible. So family members, you might be wondering, well, what would they qualify for? And they could qualify for mental health counseling, but in the cases where maybe the direct victim was deceased as a result of that incident, they could qualify for funeral and burial, support loss, and I will talk more about that as well. So we have what we call our direct victim. That's the individual who sustains that actual physical injury, threat of physical injury, emotional injury, or fatality. And the derivative victim is going to be an immediate family member of that direct victim. But then we also have, in addition to these derivative victims, we have others who can also get help, and that would be survivors of a victim. So maybe they're not related, but they were dependent on that victim for support. They would qualify. Anybody who becomes legally liable for an expense of a direct victim, so that might be a medical expense or it might be funeral burial, could file with our program, again, even though they're not related. Anybody living in the household at the time of the victim would be eligible, even though they're not related, or previously lived in the household, and this would be for a period of 2 years in a relationship similar to spouse, child, grandparent, grandchild. So an example of that would be maybe you have a couple who was married 10, 20 years ago, and but maybe they're close in relationship today, and something happens to one or the other would be deeply affected by that, could be deeply affected by that, and they would be able to apply with our program. Any caretaker, this is a good one, any caretaker for a minor after the crime, so whether it's an adopted parent, a foster parent, aunt or uncle, or even a friend taking care of minors, let's say the child was removed from the home, or maybe the parents are now deceased, could qualify with our program. And that's really important because they would probably, now taking on this minor child or children, want to get some mental health counseling to help with working with that child to bring them back to a sense of normalcy, and then also for themselves to learn how to now navigate this new scenario. And then a minor witness, any minor who witnesses, either sees or hears a violent crime, so they're not related to the direct victim, but they witnessed this crime, would be eligible. We don't cover adult witnesses, but if they were a family member or a fiance, so that would be a family member outside of that immediate court that I talked about, so that would be like an aunt or an uncle or a cousin who witnessed the crime, then they would be covered as well. So you can see our fingers stretch way out there we want to try to make sure that we don't bar anybody from eligibility who otherwise could really benefit from our program. We do have some determining factors. Timeliness, I talked about the filing period. I'll talk a little bit more about that because there are caveats to that. Residency, if they're a resident of California, they're automatically eligible for our program. Crime documentation, we have to look at. When we talk about crime documentation, for us, it doesn't mean just something from law enforcement. Crime documentation for us could be all kinds of things, and I'll talk about that as well. Cooperation with our programs, of course, we have to have a certain amount of cooperation because we have to be able to process the application with certain information and documentation. And then cooperation with law enforcement is really important, because remember I mentioned some of our funding is restitution, and that's where the In every criminal case in which an offender is convicted, restitution fines are required. And so that's a part of our funding. So it's important that they cooperate. Although having said that, sometimes there might be a reason somebody doesn't cooperate with law enforcement. You know, maybe they're afraid of law enforcement. Maybe they're afraid of retaliation. So there could be a multitude of reasons why they don't. And we're not going to bar them from eligibility. We just want to know if they didn't cooperate, why didn't they, and was that reasonable? And then that would be sufficient. And then we also look at involvement. What was the victim doing leading up to their victimization? In other words, were they provoking the suspect by their actions? Was it expected that they would be injured or victimized? We're going to look at that, but there are ways to mitigate as well. So, but just keeping in mind, these are, you know, when we're looking at determining eligibility, there's a lot of different factors that we have to look at. I mentioned our filing period now is 7 years from the date of the incident. It used to be 3. We would like to someday see that there's no filing period, and we are working towards that. But right now it's 7 years after the date of the incident, with the 7 years after discovering an injury or death. And what that means is, let's say we have a victim that went missing, let's say 20 years ago, and they just found the remains 2 years ago and determined that they were a victim of a homicide. It would be 7 years from the date of that discovery. Your PowerPoint that you have, I made a change this morning, shows that minor victims have until their 24th birthday, and then it says minor victims of sexual assault have until their 28th birthday. Well, the legislation that passed January 1st, adding the 7 years, now minors, it doesn't matter what they were a victim of, whether it was a sexual assault crime or any other crime, all minors have until their 28th birthday. So just make sure on your PowerPoint that you make that correction. And I apologize for that. Then if an application's late, there are reasons that we can overcome a late application. So if you're filing an application and you think it's late, we always encourage you just to go ahead and file it. Or if you think the victim was involved in the event, or you think that maybe they don't qualify for whatever reason, we always want you to file the application. And I really stress that because sometimes I work with some advocates in the county and say, well, we didn't file it because the victim didn't cooperate with law enforcement. And I say, don't make that decision, let us do that. Because as I mentioned, there's ways for us to overcome or mitigate certain issues that are at hand. So for example, let's say the crime took place 20 years ago and now the suspect is scheduled for a parole hearing. That's going to be a reason for an application to be filed, even though the crime took place 20 years ago, or that suspect is actually getting released from incarceration. Or maybe the suspect was just located in the last couple of years and now they're going to trial. The victim's going to be testifying at the trial. Again, the crime could have taken place 20, 30 years ago. Doesn't matter. This would be a way for us to overcome that late issue. But then in addition to that, we always look at physical, emotional, psychological, developmental conditions, age. So we always want to, you know, see if there's a way for us to overcome an issue, we want to be able to do so. And we don't like denying applications. We like allowing them. Sometimes we can't because we do have to follow our statutes. But if there's any way for us to overcome an issue, we're going to try to do so. And that's why it's really great when we see an application come in and it's being represented by an advocate, because then if we have an issue, we reach out to you as the advocate, because you might have information. You might not know what all we have or don't have. And we're going to say, hey, you know, this is what we're looking at. We are up against a roadblock. Is there any other information that you might have that you can share with us? And occasionally you do. So that's great. We'd love to see it when you're representing a victim on an application. And then if there's a new loss incurred, so this is kind of newer. Let's say somebody 20 years ago, and especially when you're looking at domestic violence and you have minors in the household, but they never filed an application and they never sought any kind of treatment. And let's say now they're 28, 29 years old, they're getting into a relationship, something triggers that trauma that took place 20, 30 years ago, and they want to start going to counseling. They never incurred an expense previously associated with that domestic violence. Then that new loss could be a way for us to overcome a late application. And I apologize, it looks like my slides are kind of, the text is not cooperating. And I think it has to do with my laptop here at home versus my desktop at work. So again, apologies for that. But your slides that you have should be, have the information available and able to be seen. So I mentioned residency. Anybody who is a resident of California is eligible for the program. Anybody who becomes injured in California, no matter where they lived, is also eligible for our program. Any member of the military, so if we have military stationed in California and let's say their permanent residence is New York or Florida, as long as they're stationed here, we consider them a resident, as well as any family members living with them at the time of the crime. They don't have to be documented, so we don't look at any of that. We don't look at their financial situation. It doesn't matter if somebody is completely unemployed or they're making, 6 figures a year, they're eligible for our program. And one of the things I hear from advocates is they say, well, they have medical insurance, or, they want to save the funds for somebody else. They have the money. And I always say, just apply. They don't ever have to use it, because maybe they have insurance today, but they won't have it tomorrow. Maybe they have a job today and a good income, but they might not have it tomorrow. And in addition to that, there's always out-of-pocket expenses. Even though they have medical insurance, you have prescriptions, you have co-pays. And so we always want to make sure, especially now because there is a filing period, that they just get the application filed. And again, don't ever have to use it. It's not like we're going to pick up the phone and say, hey, you're not using our program, but it's there for them for the life of the program or until they exhaust that $70,000. I mentioned crime documentation. So even though, if it gets reported to law enforcement, of course, we want to have a copy of the crime report if there is one available. And you might, if you want to share at this point, because I know sometimes with the tribal communities, it works a little bit differently. And I know for us, sometimes it's difficult for us to get crime reports. But I want to make sure that you know that crime documentation for us can be a lot of things. It can be a child protective services report, adult protective services report. It could be a restraining order, medical or mental health records, an affidavit from a human trafficking caseworker. We also look at along the medical lines of SART if they got a SART exam. You have the Title IX campus report, anything on letterhead from a battered women's program that identifies the incident that took place. And so if there's documentation other than an actual crime report, we just have to make sure that that documentation states what it was that took place, when, where, suspect if they have one, and then as much detail about the incident as you can, so that we can substantiate that we do have a qualifying crime. For us, we're not like a court of law where it has to be beyond reasonable doubt. We're just that 51% preponderance of evidence that a qualifying crime did occur. So there's a lot of ways that we can do that. The last bullet that you see, and this is fairly new in the last couple of years, this is specific to sexual assault victims, where if we have a credible witness, so let's say a lot of times sexual assault victims, they don't go to law enforcement, they don't get medical treatment, but maybe they went and told their best friend. That person just a letter. Again, it's got to be very specific to what took place, when, where, as much detail as possible. And if we deem that to be a credible document, that alone could be sufficient that this victim is a victim of a sexual assault. And so that was huge for us, so that we, again, make sure we're not barring anybody from eligibility. If anybody has any questions at this point about anything, or please feel free at any time to chime in if you do have a question. So any questions at this point? Okay. So looking at, I mentioned about involvement. Elizabeth asked if you can repeat who is the credible witness and what is their documentation required. Yes, absolutely. So credible witness is basically going to be anybody that a sexual assault victim went to about the incident that took place. So it might be their pastor, it might be a best friend, it might be their parent, and a letter from that person just stating what it was that they told them took place, when, where, as much information as you can give us, because we have to know when, because we do have a filing period. So if it was something that happened 10 years ago, doesn't mean we're not going to allow it, because again, we might be able to overcome that late issue. But where it took place, again, it has to be in California if they're a non-resident. If they're a resident here, it could have taken place elsewhere, as long as they resided here at the time. So again, as much information. If you are up against that and you're not sure, that's why I was saying wherever you're going to be filing applications, build relationships with those processors, or myself as well. I'm always here via email, phone. If you ever have a question, it's pretty much what I do all day, is the training and fielding questions from advocates such as yourselves about different scenarios. And inevitably, when I'm out presenting, I have an advocate approach me saying, hey, this application was denied and I don't think it should have been. And I'm like, okay, let's talk about it. And occasionally we find out that staff made an incorrect call, and we can overturn that application on the board's own motion. So anything at all that you have question-wise, reach out to your processor or myself, and we'll walk you through whatever you need. So, but the credible witness, yeah, anybody that victim went to describe that they were a victim of a sexual assault, and then relaying that information to us via documentation by itself could be sufficient. And if we get the documentation and we look at it and go, well, it's not really enough information, we're going to reach out to you and say, hey, we're not just going to go ahead and deny it. We're going to be looking for more information again, so that we can try to allow that application. So hopefully that answers that question. Now, looking at denial due to involvement, we do have to look at what was the victim doing at the time that they were victimized, because if they were involved, especially when we're looking at gang activity, things like that, did the victim provoke or aggravate the suspect? Did the victim know that by their actions it was reasonable that they would be victimized? So those are things we're going to look at leading up to it. But again, there's a lot of ways for us to overcome and mitigate those issues. And some of them might be, maybe the victim was provoking, but it wasn't sufficient to the level of the injury that they sustained. Or maybe a third party entered into the picture and the victim was victimized. We also want to look at their age at the time, their physical conditions, psychological, or any other compelling health or personal safety concerns. And an example I like to give is years ago when I was doing eligibility, I had a situation where a victim, he was in his 20s. We get the crime report, he applied as a victim, and in the report it showed that he had provoked the suspect very aggressively. And so I was going to deny the eligibility, but in talking with the advocate, she said, yeah, but he's 28, I can't remember the age, but he has the mental capacity of a 13-year-old. Well, that was nowhere in the crime documentation, and that makes a huge difference. And so we were able to verify that and overcome that issue and allow that eligibility. So any information that you have when you're working with your victims that you can pass on to us that might not be in the report or any other information or documentation that we have could be really helpful. Some of the crimes you can see here, we cover a lot of different types of crimes. You probably already know domestic violence, sexual assault, cover a lot of vehicle crimes, human trafficking, child endangerment, stalking, bullying, and a lot of times there's cyber crimes nowadays are very prevalent. We do cover cyber crimes, terrorist threats, robbery, burglary. Just keep in mind that we're looking for those four elements, that physical injury, threat of physical injury, emotional injury, and your sexual assault crimes and fatalities. So for example, if we have somebody who's at work and there's a home invasion, um, that's not going to be a qualifying crime because they weren't there. There was no physical injury or even a threat of physical injury. So those are the part of the criteria that we're looking for. Our vehicle crimes, I'll just touch on real briefly because it's really important to know that we do cover, anybody that's becomes a victim of a crime where somebody's driving under the influence, they're going to be eligible for our program. Hit and run, anytime a vehicle is used as a weapon, and this doesn't just mean an automobile, this could be watercraft, aircraft. We've even had a situation where a wheelchair was considered the vehicle. So we want to look at all those scenarios. And again, if you're not sure, I would say just go ahead and file the application. Let us make that decision, but have a conversation with your victim or their family that you're working with saying, we know this to be their criteria, but there are ways to overcome. So then they're not, there's not false hope that we're going to go ahead and be able to assist them. So sexual assault. Again, looking at the different types of documentation, because we know a lot of times they don't report it to law enforcement. Again, if they do, we want to see a copy of the report. And many times when they file the report, they want to be confidential. We have to be able to tie in our victim to that crime. So if you know that there's a report and they are named as confidential victim, we do need the 293 form, which identifies them separately. Medical mental health records again, SART exams, CPS, APS reports, the Campus 9 reports, and again, the credible witness is huge and newer. This was just in the last couple of years that we added a credible witness to our types of documentation. Domestic violence, pretty much the same thing. I mean, you see what's identified here, but if there's another form of documentation outside of this that we can substantiate the crime of domestic violence, we want to see what it is. Maybe by itself it's not going to be enough, but maybe a couple different pieces of documentation would be sufficient. Again, like I said, we're not like a court of law. We just have to have that 51% preponderance of evidence that a qualifying crime occurred. If you're working with domestic violence victims, and it's going to be a restraining order that you're going to use for verification of the domestic violence, we do have to have the request for restraining order. A lot of times we get sent the order itself, and that's not sufficient because it doesn't tell us what happened, when, where. It just tells us that the judge put an order in place for that protected person. And the request for restraining order, the DV-100, is going to be where they describe what it was that took place. So we always have to have that request for restraining order. Then sometimes there's a violation of restraining order. That by itself could be sufficient. Again, if there's physical injury or a threat of physical injury, that by itself would be fine. But a lot of times on the restraining order, the judge just imposes and says the perpetrator can't go within 100 yards of the protected person's school or home or work. And let's say they violate the restraining order by going within 100 yards. That is not going to be sufficient for us because there was no injury or threat of injury. They just violated it by either or texting the person, but again, with no threats. So if we have that scenario, we're going to need more. But then we'll say, okay, well, we have an order. Why was the order put in place in the first place? Let's go back and look at that request for restraining order. So we're always going to need that. Human trafficking, we also cover that is at the forefront of our news. We know that law enforcement now is creating special task force for human trafficking. We have faith-based organizations creating workshops and seminars to make sure that there's awareness about this horrific crime. And so there's so many different forms of it. And again, documentation can be varied outside of law enforcement. Human trafficking caseworkers can attest by an affidavit to the fact that a victim is a victim of human trafficking. And so again, just pointing out that there's all different kinds of documentation that could be accepted to substantiate different types of crimes. I do want to say with human trafficking, and this is true even with domestic violence or probably any crime, but we see it more with human trafficking where the victims are branded either by tattoo, burning, cutting. If a victim is branded by their perpetrator, our program would fall under their medical benefit, would pay to have that tattoo removed, scarring, um, cosmetically removed or fixed, any type, again, burning, cutting, things like that. Or if they have a tattoo and they don't want it removed, but they want to redesign it, we'll pay for that as well. And that's kind of newer in our benefits that were incorporated in. That's a lot of our crimes that we cover. I'm going to get into what our benefits are. So any questions on any of the crimes, or if there's a crime that you're thinking of that I didn't mention that you want to know if it's covered under our program, go ahead and put your question in the chat box, and I can get that answered for you. One of the materials that I sent out to you was our benefit reference form, and this can be downloaded off a great resource for you. I keep mine with me everywhere I go, just because it really identifies what our benefits are, and then it tells you who's eligible. So whether it's the direct victim is eligible for that benefit or just the derivative. For example, mental health. Direct victims are eligible for 40 sessions. Derivative victims, depending on what type of derivative victim, are eligible for 15 or 30 sessions. It shows you relocation. We have caps I mentioned. Even though our overall benefit is $70,000, we have caps. So home security, for example, is $1,000. Crime scene cleanup is $1,000. Medical, it goes up to $70,000. We have in-home care. Support loss, income loss, those are both a maximum benefit of $70,000. Funeral burial is capped at $7,500. So I'll get into these actual benefits a little more specifically. And again, let me know if you have any questions at all. We don't typically cover personal property. However, we can, depending on the scenario, especially in domestic violence cases. If we see that a victim had to move immediately and just went with the shirt on their back because of having to get away for safety reasons, there are occasions where we can pay for food, clothing. A lot of times their cell phones get either destroyed by the perpetrator or they had to leave it behind. We can pay for that. Those are all on a case-by-case basis, but I just want you to know that we will consider any expense that you submit to us. There's just some that, depending on the scenario, that we might not be able to pay. But under medical, we can pay for personal property if it's something that's medically necessary. So you're looking at eyeglasses, wheelchairs, canes, prosthetic devices, anything that is needed as a result of a crime, or maybe a victim had a disability prior to the crime, had one of these personal property items that was medically necessary, and in the commission of the crime it was destroyed or lost, then we can pay to replace it. That's a $70,000 maximum benefit, so there is no cap on that other than our overall benefit. So you can see here some of those medically related items. Again, wheelchairs, medical beds, and it's not limited to these. So anything that is medically related and necessary as a result of the crime, or again destroyed as a result of the crime, we can cover. And so this is just giving you some examples of what those items might be. We cover medical and mental health. So again, our medical, it's up to $70,000. Our mental health benefit is $10,000 cap. That is a soft cap. We cover 40 sessions for direct victims. So let's say they've exhausted those 40 sessions. All we're going to need is something from the mental health provider. It's what we call an ATP. It's an additional treatment plan saying that, yes, this victim needs more sessions ongoing sessions, and so we'll review that, and if it's determined that yes, they do need those additional sessions, we can allow them. One of the comments in the chat box is for emergency food, clothes, cell phone, will those funds come from their relocation allowance? And that is a great question. And yes, it does. It's all part of the relocation. But I'll talk about that because our relocation, while it's a $2,000 benefit, which I know everybody is like, that's absolutely crazy because that's barely even a deposit on a place. We know that, so I'll talk about that because we do have the ability to go above that $2,000. And I think that might be the next slide or two. So going back to our medical and mental health, one thing I do want to point out is, remember I talked about our vehicle crimes? We will cover a victim, let's say they're a victim of a drunk driver and they have an exorbitant amount of medical bills, but let's say they were also unable to work as a result of the crime. So now they have medical bills and they have a loss of wages. $70,000 may not be quite enough to cover all that they need. So they can tell us, hey, I don't want you to pay my medical bills. I just want you to pay my wage loss. That way, with reimbursing them for the lost wages, they can either pay their medical bills, but more importantly, they can pay their rent or their mortgage, put food on the table, whatever necessities are needed for the household. And I really want to emphasize this because they get to determine how those funds are distributed. And if we don't know, let's say we get an application in and they're a victim of a drunk driver and we start getting these medical bills, staff will start paying those medical bills, but nobody told us that they were also unable to work. Well, that 70,000 can get exhausted really quickly, and then all of a sudden they have nothing to pay for their wage loss. So we want you, I want to let you know that they tell us, hey, I want my wage loss. I'll worry about the medical bills later. And that's true with any of our benefits. They can decide this is where I want to utilize my $70,000, you know, funeral, burial, wage loss, whatever the case may be. But if we're not told, then staff is going to start paying bills as they come in. And believe me, providers are very savvy about our program. They start submitting bills, and we don't, right then, we're not going to call the victim and say, hey, do you want us to pay this bill? If it's sent to us, they start reviewing and they'll start paying unless somebody tells us otherwise. So I just want to make sure that you're aware of that. So you can see here a lot of the different services under medical, hospital, surgery, prescriptions. Like I said, a lot of times the claimants will say, well, I have medical insurance, so I don't really need your services, but there are a lot of out-of-pocket expenses that are associated, even though somebody does have medical insurance. Or like I said, maybe you have it today, but not tomorrow, and there's ongoing medical bills or mental health counseling is needed. So I always encourage, please just file the application, and then again, you don't ever have to use it if you don't want to. And especially for minors, I hear that a lot with minors. They say, well, they don't want to file for the children because they don't want to, they're not going to put them in counseling. They just want to, you know, deal with and process on their own. But again, what if that minor, you know, is no longer on their parents' coverage? The example I gave earlier, they're 28 or 29 years old. Now they're in a relationship. Something triggers that trauma, and they filed an application, or their parents did for them 20 years ago. They can start using the program. It doesn't matter if, you know, nothing happened for 10 years or 20 years or 30 years. We're here for them as long as that application was filed timely and they haven't already exhausted that benefit. One of the other documents that I sent you was a FAQ for our telehealth. It's a temporary scenario given the COVID-19 situation that we're in. We do cover telehealth. We cover 5 sessions right up front without any question. Anything after that, we have to do further verification. But right now, with the shelter in place, It is unlimited, so I did send you that FAQ that should hopefully answer any questions you have with regard to telehealth. Right now, it's unlimited sessions. So if you're utilizing that benefit for your clients, just take a look at that FAQ. And if you have any other questions outside of that, just let me know and we'll make sure we get them answered for you. So we've made some changes there, realizing that victims right now aren't able to go into facilities to get the mental health treatment that they need. Dental expenses we cover. Somebody, punched in the mouth, or again, a drunk driving incident where they have dental injuries, we can pay for. That is a benefit that is up to the $70,000. Sometimes some of the treatment might not be it's necessary, but the victim could live without having that treatment done. And so they want to make sure our program is going to be able to pay for it before they have it done. We don't want anybody incurring any costs for anything if they don't have the ability to do so, but they're not sure we're going to be able to cover. You can always ask us. A lot of times we'll have the dentist send us a pre-op and say, hey, what is it that you're going to be doing? We can review it and say, yep, we can cover that, so they don't incur that expense and then find out that our program's not going to be able to pay for it. And again, that's with any of our benefits: funeral, burial, relocation. And having said that, our program, so what we look at ourselves, we're the payer of last resort. So any insurances out there, any recoveries, so insurance might be medical, homeowners, vehicle. Recoveries might be if they filed a civil suit, or there was a life insurance benefit out there. We look to those first, and then we'll cover what they don't. But if they don't cover, we'll go right ahead and pick up. But we are the payer of last resort, so we want to make sure that, and when you're filling out the application, that you provide us with all of that information, and we can determine if we can go ahead and pay. So they might want to find out from our program first if we're going to be able to cover a certain benefit, again, before they incur that cost. The other thing I wanted to add is that we're also considered a reimbursement program. And so what that sounds like is that the victim has to incur this cost first, and then we'll reimburse them. And that is not the case at all. Especially mental health and dental medical providers, we want them to bill our program directly because we do pay them at a reduced rate. And so this is how it works. Once a victim files an application with our program and they get our very first initial letter that says, we have your application, here's some frequently asked questions. Once they get that, and if they pay a provider directly and submit a receipt to us, we're only going to be able to reimburse them at that reduced rate. So again, we want the providers to bill us directly. So obviously the provider's accepting that reduced rate. And I know that sometimes based on that, it's hard to provide or to find mental health providers that they can work with that will accept our rate, but there is a lot of them out there. But let's say they file the application today and they get that letter from us, but they had expenses going back a year ago or 2 years ago, because that's when the crime occurred. Prior to getting filing with our program and getting that first letter, we'll reimburse them at 100%. It's just once they get that letter from us, and it does explain all of that in there, they're only going to be reimbursed at that reduced rate. And the other point I want to make is that those providers that are accepting our reduced rate cannot turn around and bill the claimant for the difference. That is against the law, and I've seen that happen where we pay them whatever the rate is, let's say 70%, and they turn around and bill the victim for the other 30%. They cannot do that by law. So I want to make sure you know that too, that if your client is getting mental health counseling with us and we're paying the provider directly, that provider cannot bill them for the difference. Any questions from anybody? Okay. I don't think I talked about, and I want to make sure we also cover what we call CAMS. and that is complementary and alternative medicines. There's a lot of different things we cover. It includes a number of non-medical treatment modalities that fall outside of the general definition of traditional medicine. So, for example, complementary medicine refers to like healing practices and products that work in conjunction with traditional medicines. For example, let's say a patient receiving pain management treatment through a prescription may also undergo acupuncture to help manage the side effects. And so some of those examples would be music therapy, equine therapy, massage therapy, yoga. So I want to make sure that I point that out, that there are lots of different types of alternative medicines other than the traditional. And if you're not sure if it's something we cover, and again, it's a treatment they want to do, you can ask us first. We cover, I can't remember if it's the first 3 or the first 5 without, oh, it is the first 5 without any question. And then after that, we do have to have a referral from their primary physician that alternative medicine is necessary for their recovery. And then we can go ahead and continue to provide more treatment. Okay, so support loss. Would the cost for traditional healing ceremonies be covered? Most likely, again, they're going to be on a case-by-case basis. So send us, let us know what that actual method is, and we can make sure that's something that we can cover. But most likely, the answer to that is yes. So support loss we cover, and this is for a derivative victim who was legally dependent on the victim. So it could be a minor, or it could be the spouse or domestic partner of somebody, or it could be an incapacitated adult who is relying on that other adult for financial support, and that adult becomes a victim and is deceased as a result of a crime. Then the minor, the incapacitated adult, or the partner, or even an unborn child, but they were conceived at the time of the crime. They're born, 4 months, 8 months later, is eligible for support loss, and that's up to the $70,000. And it's for minors, it's until they reach the age of 18 or that fund is exhausted. In the case of support loss, though, this is a shared benefit. So if we have 3 children living, let's say, that we're relying on support, again, they're each going to file their own application, but that $70,000 is shared. So it's going to be divided between the 3 children, and let's say one reaches the age, or it's going to be for the benefit of all 3 children. One reaches the age of 18, let's say there's 50,000 less, now it'll be to the benefit of the 2 remaining children until, again, it's either exhausted or they turn the age of 18. One of the comments on the chat box is, do the significant others who have applied and are approved have access to the same CAM services? And that's going to be on a, sorry about that, we have somebody in the background. That is going to be on a case-by-case basis. They definitely could be. So again, file the application, or if I encourage you to file the application, but I know sometimes you don't want to go through that trouble of the victim having to go through that trouble if it's not going to be something we can cover. So shoot the scenario by, again, your processor or myself. I get those calls a lot where they say, this is what happened, this is the crime. Of course, I can't give you a definite yes or no without seeing all the documentation, but I could certainly give you a good idea of whether or not it's going to be a crime that we can cover or a benefit that we can cover. So don't hesitate to do that ahead of time, anytime. So again, the support loss, that can be of huge benefit for somebody that loses a loved one who they were dependent on. So when we're looking at legal dependency, this is kind of an idea of what we're looking for. Child support records, this is to determine that that person was legally dependent on the other. For our verification, I will say a lot of times we, how how do I want to say this? We, you know, like if we get an application and we have a parent filing for a child on behalf of a child, we don't say, okay, we need to see a birth certificate to prove that that child is yours. If we see a red flag, we're going to look at it, but we don't always, you know, we're just going to take them at their word that that child was in fact their child. But when it, I mean, and this is for applications for mental health counseling and other things, when it does come to support loss, we do have to verify that that person was dependent on that other person. So again, birth certificates, marriage certificates, things like that, anything that's going to identify. So we've had cases where we have two people living together, they're not married, um, and we have the victim is deceased. If we can show through, and usually it's going to be through tax records, that that person, either they were claiming that minor as head of household, or that that person showed on their tax returns that they were financially responsible for this other person, that's going to be really significant for us because we do have to verify that in those situations. So this gives you an example of some of those documents that would assist us in that, but again, not limited to. So we'll touch on relocation. I think I skipped a, let me see back here really quick. Yeah, income loss. I don't know why that went right by that, but income loss, of course, we cover. So somebody loses wages as a result of a crime, will pay up to $70,000. This is for the direct victim, and this is going to be, again, for 5 years or until they exhaust that fund. For a derivative victim, we can pay income loss if they have a minor who's either hospitalized or deceased as a result of a crime. We'll pay up to 30 days wage loss for that adult. So let's say we have a minor hospitalized for 30 days and then they succumb to their injuries. We potentially could be paying up to 60 days of wage loss for an adult in that scenario. So moving on to relocation. We do cover relocation, and as I mentioned earlier, it's a $2,000 benefit, which is almost embarrassing for me to say because, as you know, you could barely cover a deposit on a home or a rental, and especially when you're looking at San Francisco, Los Angeles. And so we did legislation was introduced previously to increase this to at least 4,500, but the legislation did not get signed. And it wasn't because they don't want to be able to assist the victims this way, but if, as you can imagine, legislation, sometimes one little word, the language isn't satisfactory, and so the whole thing gets thrown out. So we are working on that, trying to increase this with relocation. So the benefit of 2,000 can pay for a lot of different things. But part of the criteria, if somebody is requesting relocation, is that we either have verification from law enforcement that it's necessary for their physical safety, or verification from a medical or mental health provider that it's necessary for their emotional well-being. We do have to have one or the other of those two verifications in order to pay for relocation. Now, we do have what we call a UDE, and this is unusual, dire, or exceptional circumstance that meets the criteria. We can pay above that $2,000, and for that, there is no cap other than the $70,000. Now, I don't know that we've ever paid. The only thing I've seen personally is we've paid up to almost $20,000 to relocate somebody. We have to verify, like I said, there has to be certain criteria to meet this UDE, but so for one, that there's an ongoing threat to the victim. It creates a substantial impairment of their daily activities of living. And so if you are filing for relocation on behalf of your client, I would say submit us all the receipts that you have. And that would be anything associated with the move. So like I talked about, normally we don't pay food and clothing. Submit those receipts if they have them, but we pay for U-Hauls, we'll pay for mileage, we pay for storage, we pay for hookups of utilities if it's required. If the landlord's requiring insurance, property insurance, we can pay for that as well. So what I'd want you to do is submit everything as if it's going to be a UDE, and submit everything to us, even if it's over the $2,000, and then let us make that determination whether it meets that criteria. One thing with the UDE, and I'm not sure where this came from, but it does require that there is a minimum of 30 miles that the victim moved. And this is so, remember I said we need either verification from law enforcement that it's necessary for their physical safety, or a medical or mental health provider that it's necessary for their emotional well-being. Well, under the UDE, if they're moving because it's necessary for their physical safety, they have to move at least 30 miles. So if you're requesting UDE and it's based on their physical safety and they're not moving 30 miles, then forget the law enforcement verification. Find a medical or mental health provider that will give us a verification, because then that requirement that they move 30 miles is not in place. Again, I don't know where that came from or who came up with that restriction. We are obviously well aware of it and trying to get that removed, but some of our criteria that we have to follow is legislation, it's law, and so we can't bend, but we do work on changing. So again, if you're submitting under the UDE and you know they're not going to move 30 miles, then get the verification from a medical or mental health provider that it's necessary for their emotional well-being, and forget law enforcement altogether. Because we know 30 miles, somebody doesn't have to move 30 miles in order to feel safe. They could move 5 miles down the road. And especially because moving 10 miles or 20 miles or 30 miles puts them outside of, school zones that the kids are going to, school districts, so they're going to school in this district, but then now, we're saying, well, if you're moving for your safety, you have to move 30 miles. That just makes absolutely no sense. So we're trying to do away with that. And there are ways around that, as I mentioned. Just get the medical or mental health provider to support with their verification. And I do want to just really reiterate again that the victim doesn't have to be out that expense and then we reimburse them. We can pay the provider, the landlord, directly. So what they'll do is, we have on our website a relocation packet. I would suggest sometime that you go download that. It has a worksheet. It has a W-9 that if we're paying the provider directly, they have to submit a W-9. It has other information in there. It has the relocation verification for law enforcement as well as the medical and mental health providers. You know what those forms are to get them completed. And then there's all kinds of things that we can cover. So anything associated with the move, again, like I said, U-Haul, storage, there's all kinds of costs incurred when somebody's moving. And then if we can just pay the landlord directly, because we don't want the victim to be out of pocket if they don't have to be, we can do that. We'll just pick up the phone, call the landlord, say, hey, did they move in, or are they going to move in? And this is the information we have, and we'll just verify it that way. So we want to make sure that they're not out the expense if we can go ahead and pay directly. A couple of things on the chat line. Actually, I think just one more. For emergency food clothes phone, how would we request that? Will those funds come from their relocation allowance? And yes, those funds do come out of the relocation. So again, the standard benefit is only $2,000. So make sure you ask for your processor to elevate it and see if it meets the criteria of a UDE, and we can pay over that $2,000. And if it meets the criteria to allow us to pay for food, clothing, cell phones, things like that, then we will. One of the examples that I also like to give is that we had a victim who was shot by, it's a domestic violence incident. She was shot by her perpetrator in the back. She wanted to relocate. She didn't have any family or support in California. Her family, the closest, was in Texas, so she wanted to relocate to Texas. She was being threatened by the victim's family, so it was very apparent that she needed to move for her physical safety, not to mention, emotional well-being as well. But she couldn't fly. She couldn't drive. She couldn't take a bus because of she was paralyzed from the waist down, and because of her disability, she couldn't sit for any length of time in one position. So it was like, how do we get her to Texas? Well, a friend of hers from California offered to drive her there. So this way, he could stop whenever needed. He or she, I don't remember what it was, could stop whenever needed to let the victim get out of the vehicle. Obviously, they would need hotel, food, things like that. So we were able to pay all of that and the mileage for this person to drive her to Texas. And I believe she had a couple of children. And then, of course, like I said, hotels along the way. Well, then now this person, they don't live in Texas, the friend that drove her there. So we were also able to pay the mileage to get that person back to California. And I think on this we paid somewhere around $8,000, $9,000. And so we're able to do that. We like to, think outside the box, so to speak, whenever we can to pay for any of these extra benefits, because we'll pay for airfare, we'll pay for busing, we'll pay for mileage, whatever it takes to get that person to where they need to be, is what we want to be able to do. So the other question on here, would we need to submit law enforcement or mental health relocation forms? And yes, always. Anytime asking for relocation, whether it's a regular or that falls under the UDE, we always need one or the other law enforcement or mental health verification forms. And again, that's all part of the packet you can download on our website. So having talked about relocation, just a couple little questions for you that I'll throw out there to see if you can answer them. And the first one is, during the course of a home invasion robbery, you have two roommates and they're both home and each is threatened with bodily injury. Would we be able to pay relocation? And you can answer that on the chat box if you think yes, and if you want to say why you think that's true. I'll just give you about a minute to do that. So we have a home invasion, two roommates are home, each is threatened with bodily injury. So good, you guys, yeah, yes, and I like that you elaborate, both have been threatened, and that's absolutely right. So each roommate is eligible to receive relocation benefits of $2,000. So again, you're gonna file two separate applications, because in that scenario, by threatening both of the roommates, the perpetrator has essentially committed two separate crimes. So they're each going to be eligible for $2,000. Now, if they move together, like as a unit, a family unit, then it's only $2,000. But they're unrelated and moving separately, they would each have benefit. Okay, so during the course of home invasion, robbery, perfect, great, thank you for confirming. We have one roommate is home and killed by the perpetrator. So the surviving roommate can qualify for relocation award as what we call a roommate survivor, is a type of derivative victim. So remember, we talked about derivative victims being immediate family members, but then we had some caveats to that, and this is one as well. We call them a roommate survivor, and they eligible for relocation. So we have a home that's burglarized when neither roommate is home. Are they eligible for relocation? Do you know the answer? I love it. Exactly. So neither roommate is eligible for relocation benefits. If no one is home, you're absolutely right. There was no physical injury or threat of physical injury, so therefore we don't have a qualifying crime. A threatening note, that's very interesting that you bring that up. And I would say on the surface, probably not. But this is where we always like to think outside the box. So I would have that conversation with your processor or myself and see how that goes. Because let me give you an example of not quite that, but we had somebody who was at work and they had a home invasion. So they're not home. Physical injury, threat of physical injury, most likely not present. But what happened was, you know how a lot of us have those ring devices on our doorbells? This person, I think it was a gentleman at work, his ring was activated. The perpetrator was at the door trying to break in and actually speaking into the ring device. I'm going to effing kill you, come back, I'm going to get you, I'm going to do this, I'm going to do that. That was a threat directly to that person and obviously was recorded. We were able to allow that application. So I love that thought of the note. I don't know that that would be sufficient, but again, we want to take a look at that and that scenario and see if that is a way that we could allow. So great thought on that. Okay, last one. During the course of a home invasion robbery, one roommate is home and is threatened with bodily injury and survives. The second roommate is not home at the time. Is that second roommate eligible for relocation? What are your thoughts? I got a no, another no. So in this scenario, you're absolutely right. Again, you guys are awesome. Only the roommate who was threatened qualifies for the relocation benefit as a direct victim. There's no relocation benefits for the second roommate because that roommate was not home, therefore not threatened with injury or actually injured, and we don't have a qualifying crime. And the first roommate is not deceased. Because remember, if the first roommate was deceased, then the second one, whether home or not, would qualify for what we call roommate survivor. However, if we have, again, if it's a family unit, then obviously they move together because that first victim qualifies for the relocation. The second victim, whether home or not, would have ultimate benefit of that. So good job, you guys. Okay, moving on to a couple of our other benefits. We also cover home and vehicle modification. We don't see a whole lot of these, but I think it's really important that you know that this is available. This is if we have a victim who is permanently disabled, either partially or whole, but permanently disabled. And of course, we have to get a physician's verification. But we can modify a home up to $70,000. So let's say they need the halls widened to accommodate a wheelchair, or they need a ramp, or they need railings to hold on to, whatever is needed to modify that home, we'll pay up to $70,000. We'll also pay up to $30,000 to modify a vehicle, to retrofit it to meet their needs due to the disability. And if the vehicle that they have can't be retrofitted, then that $30,000 could go towards a new vehicle. So that's a great benefit also. We cover residential security. This one I really like because it used to be that, like relocation, we had to have something from law enforcement that it was necessary for their safety, or a medical or mental health provider that this residential security was necessary for their emotional well-being. We completely removed that. So essentially, anybody that qualifies with our program can get a residential security system. It's a $1,000 benefit, and the crime doesn't have to have taken place at home. You know, maybe they're out at the mall and they get robbed, somebody grabs the purse, takes off, or they're battered, whatever the situation. I think anytime somebody is victimized, and doesn't matter where it happens, having a security system at home, if they don't already, it's going to really make them feel safe, because then whether they're home, wherever, they're going to feel really vulnerable. And so I really liked that we removed that criteria or the requirement of having law enforcement or a medical health provider verify that it's necessary. A lot of systems cost around $1,000, so that's how we came up with that benefit. And so they could go to Home Depot and buy a system. They could have ADT or Brinks or whoever install a system for them. This is pretty much a benefit that we'll pay after they incur the expense, although we have been known to be able to pay it up front. But again, that's going to be a case-by-case basis and up to the manager that's determining it. But sometimes, they just don't have the money to do it and they want to put in a system. So we have been known to say, hey, go to Home Depot, give us a receipt of what it's going to cost. And then what we'll do is we'll write a check to that person, but then we want to see the receipt that they actually purchased it. So again, those are case by case. And if they already have a security system, then we can pay for, maybe they have a keypad at the front door, but now they want one in their bedroom, or they want one at the back door. Maybe they want to change locks. Whatever the case is that has to do with the security system, or the Ring doorbell falls under that, cameras outside, anything that would be added as a security benefit. I apologize, dogs are not included. We get that asked a lot. Can they buy, a German Shepherd as their security? But that doesn't fall under this, unfortunately. And if they already have a system, then like I said, they can add to it. Or if they already have everything they absolutely need, they can use the $1,000 for monitoring costs. Sometimes they're paying, $35, $40, whatever the cost is to have that system monitored by their provider, and it ultimately calls law enforcement to respond. We can pay for those monitoring costs until they exhaust that $1,000. Benefit, another one is funeral and burial. This is a maximum benefit of $7,500. This is a hard cap, so we cannot go above that. But again, this is something that covers a lot of area with regard to funeral and burial, because we know, especially, there's so many different cultures. I'm sure the tribal communities, I don't know specifically what the cultures are there, but whatever it is that they want to do to celebrate a loved one is going to be a benefit that we're going to be able to pay and cover. So there's so many non-traditional ways to celebrate a loved one's life. For example, and things you can see here of what we do cover: cremation charges, newspaper notices, photography, musicians' fees. We don't cover alcohol, but we will cover, we had a family who wanted to celebrate their loved one by having a dinner at a restaurant and having family and friends come, and we were able to pay the bill. I think it was around $4,000. We can pay that. However somebody wants to celebrate a loved one, it's not for us to decide whether or not that's acceptable. We're going to be able to pay it. But again, just make sure that whatever they want to do, that you just know up front that we are going to be able to pay it. Again, we don't cover alcohol, but we don't want anybody incurring an expense that is later going to be determined that we can't pay, and then they're out that expense. But I want to give you another example of how we really try to think outside of the box. And actually, it wasn't us. I have to give credit to one of my advocates in Fresno. And they lost their child, their son, and what they did was they went out and bought T-shirts with his picture on it, and they had a walk. They did a walk, and then when they had the ceremony, the funeral service, everybody wore the T-shirts, and they wanted us to pay for the expense of the T-shirts and submitted the bill to us. Well, that's not something that we cover. And but what happened was, the family, the advocate had asked ahead of time to one of the managers if it's something that we would cover, and they were told yes, so they submitted the bill. Then when they went to process it, said, no, that's not something we cover. So they were told no. Well, then, of course, the advocate called and said, Cindy, this isn't right. They were told that they could, and this family's already been through enough, and certainly we don't ever want to traumatize or re-traumatize anybody any more than they already have been. So I went to one of the managers in our benefit determination section and said, hey, look, and I was still told no, we can't pay it. It's not in our statute to allow us to do so. So it was really difficult to go back and say, that's not something we can do. The advocate then came to me and said, okay, you cover picture and picture frames. Why can't we just call this a picture inside a cotton frame? I went, that's a really good thought. Let me revisit this. So ultimately, we were able to pay it. That was very awesome of this advocate to think outside the box like that. Not to say that we'll do that in the future, so I don't want you to, go out and say, yeah, CalVCB will pay for shirts with a picture of your loved one on it. We did it in this scenario because, one, the advocate really, I mean, you guys are so passionate, so you're going to push these things forward, and I love that you do. But because the family had been told yes in the first place, and then we told them no, we were able to um, allow that expense. It was only, I think, like $300 or $400, which ultimately doesn't matter how much. But bottom line is, you guys have a passion. You don't like a decision that we make, whether it's a bill that we're paying or eligibility. I want you to reach out to whatever office you're working with or myself, because I occasionally will overturn the eligibility. Let me give you another quick example because this is a really good one too. In fact, I'm going to hold off a minute to do it. Just remind me if I don't when we get to our Good Samaritan. I'll give you another great example of how our program really likes to listen to what you guys are saying when you tell us, hey, I don't agree with this decision. I don't think it should have been made. We want to make sure we take a look at it because we always want to make sure the right decisions are being made when it comes to, especially if we're denying eligibility for someone. Okay, crime scene cleanup. We also cover, that's $1,000 benefit. Anyone who assumes that liability, so this is just like funeral burial, which I don't think I mentioned. Anybody who assumes that liability, it doesn't have to be a family member, anybody related. It could be a best friend in another state. It could be an aunt or an uncle in another state or in this state. Anybody who assumes that liability, they file an application with us and we'll pay for that funeral burial or in this here crime scene cleanup. Again, they don't have to be out of pocket. We can pay the provider directly. The case of funeral burial, submit us the contract. We call the provider, verify that the cost has not already been paid, and we'll pay the provider directly. And that's really nice so that, again, the victim doesn't have to be out of pocket. So crime scene cleanup, anyone who assumes the liability. This is for bodily fluids, blood, things like that. It's not for broken furniture, broken doors. Although, having said that, if we have a situation where we have a broken door or a broken window, remember under home security, that could be paid for. So we have the perpetrator who busted down the front door or broke a window. If it's something securing the perimeter of the house, so it wouldn't be an interior door, but an outside door, we can't do it under crime scene cleanup, but we can pay for those under residential security. So crime scene cleanup, again, bodily fluids, things like that, and it has to be performed by a trauma scene waste management practitioner, somebody who's certified to do that type of work. And they're all registered on the Department of Public Health's website, so you can find them there. Again, having said that, I have heard that when we had an individual clean up a scene on their own, that we were able to pay it. I have no idea the circumstances around that, why we were able to do that when it calls for the work to be performed by somebody certified. So that's why I always say just ask and let us look at the scenario surrounding it, because even though you think it's not something we're going to be able to do, you never know. We try really hard never to deny anything, so always let us make that decision. Again, making sure that you have a conversation with whoever's going to be applying for that benefit. Hey, this typically isn't something that they cover, but let's see what we can do. Job retraining we also cover. So somebody, again, if they're permanently disabled, either partially or wholly as a result of a crime, we can pay to have them retrained into a different profession if they're no longer able to do what they were doing prior to their disability. They do have to apply with the DOR, which is the Department of Rehabilitation. They get an assessment through them. And of course, we do need verification from a physician that they are permanently disabled. This benefit is up to the 7,000, so that could be very beneficial to somebody who, again, was no longer able to do the job they were doing before and needs to be retrained into a new job. We also cover guide, signal, and service dogs. This is newer. It's been around 4 years now, but 2016, January 1st, this was law that was passed and signed, and I'm really excited to see, because we know guide, signal, and service dogs are extremely important to somebody, and if disabled or killed in where the crime is concerned, we've been able to implement this benefit so that we can pay up to $10,000 for either vet bills for that guide, signal, or service. And I'll say animal. I don't think it necessarily, well, now I'm rethinking that, whether it has to be a dog or not. I think it does, because guide, signal, and service dogs are specifically trained to perform a certain function. But hey, if you know there's another animal out there that was trained and certified, I throw that at us. Unfortunately, it doesn't cover comfort or therapy dogs, and I know that those dogs are very instrumental in somebody's recovery. But right now, it's just these dogs because they are specifically trained to perform a certain act for their owners. Derivative victims are not eligible, so we can't cover family members. It's just going to be whatever is necessary for that dog. Vet bills, like I said, or if the dog's killed, $10,000 toward purchasing a new one. The owner of the dog, of course, is covered, and pay whatever benefits that they would be eligible for, depending on the type of crime. So we do cover a Good Samaritan. This is kind of outside of our little box here of victims that we cover. And the Good Samaritan, this has been since day one that we've covered a Good Samaritan, and I really wish we'd see more of these applications, but I think it's just a training issue that, you're not aware that this is something we cover. So a Good Samaritan is going to be anybody that comes to the life of somebody who's, the aid of somebody whose life is in danger. And so this can be, like you see here, a natural disaster. It could be a drowning, it could be an earthquake, it could be a flooding. It doesn't have to be one of our typical qualifying crimes, but anybody, and it's going to be for a citizen who is not law enforcement or a firefighter, because it's their duty 24/7 to come to the aid of people whose lives are in danger. But this is a civilian who comes to somebody's aid, would be eligible for our program up to a $10,000 benefit. And the thing about this is it does cover personal property. So let's say somebody went to rescue somebody who was drowning, and in doing so lost jewelry or clothing or whatever the case is, we could pay up to $10,000 to replace those items. Or let's say, unfortunately, the Good Samaritan is deceased as a result of coming to somebody else's aid, then the family member could qualify for funeral, burial benefits, things like that. So I read about Good Samaritans, I'm sure you do too, all the time in the paper or hear about them on the news. And just know that they can file an application with our program. We do have to verify that they were acting in a Good Samaritan capacity. But two examples I have here. One, there was a situation a couple of years ago. It was here in Sacramento, a gentleman driving. I think he had a couple of children in the van. Driving down the road, the van caught on fire. A Good Samaritan came to their aid, busted out the window to help get him and the children out, got them out to safety. And I remember hearing about the story, but it was like, I think a year later, I was driving home from work, listening to a news radio station, and they were doing a story on the Good Samaritan saying that he had, and it was a year later, or maybe they were just making it known, he received a bill from the paramedics when they arrived on scene. He busted out the window to the van, and in doing so, cut his arm. So the paramedics tended to him medically. And then he got a bill down the road for $200 and some odd, and people were outraged because it's like he came to the aid of these people and really sent him a bill. So that caught my attention, obviously, because I'm like, well, hey, yeah, really unfortunate that he would get a bill for that, but he could apply with our program. We'd pay the bill for him. That was a medical expense he had. So I called the radio station and said, hey, I was just listening to the story. I work for this program. And they were totally surprised, saying, we didn't even know this program existed. And they're like, can we have a reporter call you? And I said, well, because, we have our department, our public outreach that does that. Other people ask to speak to reporters that are employed with our office unless you're specifically designated to be able to do so. So I knew I wasn't at work. I gave them my number because I knew they'd get my voicemail. And sure enough, the next day there was a call from the reporter. And so what I did was put them in touch with our outreach department. And what that resulted in was, at the time, Julie Nauman, who was our executive director, was able to go on to the show, talk about our program. And so it was really cool that that came about. The other example I want to give you is I mentioned to you how inevitably when I go out to train or do a training via webinar these days, that an advocate will reach out to me and say, hey, this application was denied, like it should have been, and I'll say, tell me about it. And what happened was this gentleman had, he was attacked by a dog. And typically that's not a crime we cover, but he was attacked by a dog. He was injured. He was able to fend the dog off. The dog turned around and attacked another woman. He went after her to aid her, get this dog off of her. The dog turned around, started attacking him again, to the point where he actually succumbed to his injuries. So he died as a result. The application was denied because, as I said, typically that's not a crime that we cover. However, my first thought was, well, wait a minute. He's okay, so maybe it's not a crime we cover. He's a good Samaritan, right? He came to the aid of somebody's life who was in danger, and in doing so, he not only was injured, he died as a result. I said, at the minimum, he's a good Samaritan. We can cover $10,000 and $7,500 in funeral. If there's I think we could, I'm not sure into this if we could pay support loss, but at the minimum, we could pay for his funeral. So we looked at the application, we were able to overturn it. And, but more importantly, or equally as important, I should say, that's not a crime we typically cover. But if we determine that this dog had previously been aggressive and it was known to the owners that this dog was previously aggressive, well, now we might have a crime because the owners knew that the dog is out. And that exactly was the case with this scenario. This dog had been known to previously be aggressive by law enforcement. The dog is back out. Now we have a crime. So we weren't only able to overturn that action and make him a good Samaritan, we were able to make him a direct victim. So now he has a benefit of $70,000, his family does, instead of the $10,000 under a good Samaritan. And so we overturned the application. So now the family, again, of course, funeral, burial, but now because he had children who qualify for support loss, he's no longer able, because he's deceased as a result, to provide them with support. So they were able to collect support loss. So I love giving that example, because that was an application that was actually denied. And had that advocate not come forward and brought that to our attention, we wouldn't have overturned that, and now that family has benefit. So I always want you to, if you believe that a decision has been made incorrectly, let us know about it, because we're all human. And as you can see from this presentation, our program has a lot to offer. So especially when we have new staff, sometimes, I mean, I can remember interviewing for the position 10 years ago, and I always thought, when I get a new job, it takes me about 2 weeks to figure it out, right? And I remember the manager interviewing me saying, yeah, it's going to take you about 6 months to really grasp this. And I thought, yeah, not me. Honestly, I learn something new every day. And, well, maybe not every day, but it's a lot of information. So our staff, sometimes they don't get it right. So don't hesitate to bring anything forward. Okay, moving right along. We're nearing the end, and we'll open it up to any more questions that you might have. We do look at if somebody is on a restricted status, so whether they're on a violent felon status or registered sex offender status, doesn't mean they can't apply with our program. They can still apply and they can still be eligible for our program. We just cannot pay expenses while they're on that status. So you might ask, well, then why bother applying? There's a couple of reasons for that. One, maybe that status expires, let's say September 10th of this year, and after that point they have ongoing medical bills as a result of the crime, or maybe they need counseling. Once that status expires, we can start paying their benefits. So we want to make sure they apply, especially again because we have the restriction of 7 years from the date of the incident. So we want to make sure they apply. Equally as important, we want to make sure their family members are eligible. So just because somebody is on a felon status doesn't mean that they can't be a victim of a crime. And so if the direct victim's not eligible for our program, derivative victims are not eligible. So by allowing somebody on this restricted status to be eligible for our program, we can open it up to also their family members being eligible. So I really want to emphasize that just because they're restricted status doesn't mean they can't apply and be eligible for the program. The application does ask for that when you go to fill it out. If you're not familiar with it, it'll say from the date of the incident to this date, have they been on any kind of restricted status. Sex offenders, they are required to do that for life. So yeah, that's probably never going to expire. But again, their family members would be eligible. Or, you know, nowadays technology, DNA, things like that, maybe they determine at some point that person wasn't actually guilty of the crime that they were accused of, and that status may be removed. Who knows? So we just want to make sure that they do apply with our program, but we can't pay the benefits as long as they're on that status. So I mentioned we're the payer of last resort. So this is just some examples of what we look for when we're paying out benefits. If there's, you know, if they have homeowners insurance, medical insurance, vehicle insurance, we want to look to those recoveries, reimbursement sources first. If they say, you know, they're not eligible or they don't qualify, then we'll go ahead and pay whatever, or we'll pick up. A lot of times there's deductibles. So let's say a crime took place at home and their homeowner's insurance kicks in, but they have a $2,000 deductible. We'll pay that $2,000 deductible. Same thing with any other reimbursement recovery sources out there. Civil suit, especially with vehicle crimes, they might file a civil suit, but they can outside of those crimes, but that's just an example. We know that they can take years to settle. It's not like we're not going to pay anything until that settles, but what we'll do is what we, so to speak, call lien the file, lien their application, saying, hey, they have a civil suit, we'll pay whatever they need, but when that suit settles, so let's say we paid out $20,000 in medical bills, and let's say the suit settles 2 years later, or they get $100,000. By signing our application up front, they're agreeing that when that settlement happens, they'll pay back that $2,000 to our program. So again, we're not going to wait for that suit to settle. We're going to help them now with what they need, and then we can collect those funds later. Also, having said that, I want to make sure I point out, you know, how everybody now does the what's the fund that oh my gosh, it's so escaping me, the help me fund, there's another word for it, that a lot of family or friends put out there if a loved one needs medical expenses or whatever. We do have to look at that as a reimbursement source. Thank you. Yes, go me. Totally drew a blank there. We do have to look at that as a reimbursement source, but here's the thing. If they do a GoFundMe account and they say this GoFundMe account is for the funeral and burial expenses of Jane Doe, we have to look at it as a reimbursement source for funeral burial. If they do the fund, and I say this, so if you know of somebody that's going to do a GoFundMe account or whatever is out there, tell them not to be specific, because if they say this is just for funeral burial and other costs for the family, then we don't have to look at it as a reimbursement source, because we know there's a lot of other costs associated with anytime somebody is injured or victimized. And so we don't want them to be specific. But unfortunately, by statute, if they are, we have to look at it as a reimbursement source. So just a little tidbit there if you're working with a family who's going to be setting up one of those GoFundMe accounts. Anytime eligibility is denied or a bill is denied, they do have 45 days to appeal. A deny letter goes out along with it's just a very informal one-page document that they just sign and send back if they want to appeal that decision. They only have 45 days to do so. That is very strict. If it's outside, we cannot accept it. So I would say if they want to appeal and you're going to assist them, just get that paper back in, and then if they have documents to support it, get those in later. Just get that reply form back in to stop that clock from running. And then you can submit the documents later, because the appeals take, I don't know, gosh, probably the minimum 2 months before they get assigned and over to one of our hearing officers. But we want to stop that clock from running. And it is a very informal one page. So if they don't even have to use that, they could take a separate piece of paper, put their application ID number, their name, and say, you know, my eligibility was denied. I don't think it should have been. This is why. Sign it. That would be sufficient. Very informal. But again, that 45 days is very strict. Just a couple other wrap-ups here. We have CalVCB online now. Victims can go on and create an application online. So they have 3 ways to do it. They can either type it up online, print it, and mail it in. They can print it, fill it out by hand, mail it in, or now they can actually go on and create an account, just like you might do with your medical. I know with Kaiser, I go on, create an account, I can get all my, communicate with my doctor. It's very similar to that. They can upload documents, medical records, all kinds of things into the system. This was just rolled out a few months ago. Providers have the ability to create accounts. Advocates, we're working on the portal. I'm in the middle of creating about a 45-minute e-learning, the modules for that, so that when we roll this out to you as the advocates, you'll have all this information in an e-learning tool to go in and walk you through being able to create an account for yourself, your client, completing the application, and so on. So we're really excited about that, because then as an advocate, you're going to be able to go in and see what the status of their application is. You're going to be able to see the documents that you uploaded. You'll be able to view the documents you uploaded. If there were other documents uploaded by somebody else, you'll be able to see them, but you won't be able to actually open them. But you'll be able to see, hey, a medical bill came in, know where the application is in the process. And so again, we're really super excited about this. And so you can see here, it'll allow you to complete an application, look at the reimbursement status, upload documents, update certain contact information, view the correspondence that's come in so far. And we also have, I mentioned to you on our website, which is victims, so it's plural, victims.ca.gov. There's all kinds of information there, but there is a page specific, or a tab specific to advocates, that I try to keep updated with current legislation. We have a training on there. It's a 2.5-hour self-paced course. It's very similar to what you just heard today, only the information's not quite as updated, and we're working on that because we have to go to an outside source to make those changes. So it's very informative. You can go on it and you'll learn a lot about what or refresh your memory with a lot about what we talked today. But just know that some of the information today is updated from that course. I do a webinar the 3rd Tuesday of every month. This month, some gets pushed out, and this month it actually is pushed out to Wednesday, May 27th. So I do a webinar from 1 to 3. This month it's going to be on income and support loss. We'll definitely take up the full 2 hours because there's a lot of information there. If you want to be on my distribution list, shoot me an email with your email, and I'll add you to that. And at the beginning of every month, I send out an email saying, this is what our topic is this month, but you can also find that information on our website under the Advocate tab. I wanted to give you the number for customer service. I suggest you call build a relationship with our processors and call them anytime you have questions. Customer service gets calls from claim providers, and so not that they wouldn't be able to assist you. They're awesome group of people who are very knowledgeable, but you might get a little more personalized service through the processors that you're working with or myself. We have our public affairs. There's the email for it. You can go on our website and download a lot of information, but if there's also a material request form you can send in and get first responder cards, posters, literature on our program. It's all free. When we send it out to you, there's no cost for postage or anything like that. Everything is completely free. So if you want 500 first responder cards and 10 posters, you just fill that out, send it in, and they'll ship them to you at no cost. I love it when I go out and do training and I go into these agencies, and I walk into the lobby and I see this big old CalVCB poster and literature sitting on the table. It's just great because, of course, we want everybody to know about our program. So as you can see, this is a lot of information, and there are agencies that have me do this every 6 months because of the updates and because of the volume of information. So don't ever hesitate if you want to have this training again. Pretty soon I'll be able to go out in person and do it. Which I much prefer because my audience is much more engaging. Not that you guys weren't, you had a lot of great questions, but there are times when I do this and nobody will ask any questions because they're intimidated, I guess, by the chat box, or maybe they're distracted doing something else. So I really like to do them in person, and we'll be able to do that pretty soon. But you have my contact information here. You have my email, my phone number. Don't ever hesitate to reach out. That's what I'm here for. And again, Cynthia and Stephanie, thank you so much. I really appreciate you guys and all of your staff taking the time to, from your probably really busy schedules, I'm sure, to listen to our presentation. And with that, I'm going to open the mic back up here. So Stephanie or Cynthia, if you want to add anything, let me figure out where that is in here. Okay, so I've shared the audio. You're free to speak. And if anybody has any questions, let me know.
Wow, Cindy, this is Stephanie. Thank you so much. That was incredible. I'm so glad to have this information. And I'm kind of embarrassed that I didn't know that much about it before. So thanks for sharing it. I really hope that the advocates on the line are able to take advantage and, get some compensation for victims. I had one question.
Yeah,
yes?
Oh, I was just going to say, in response to that, don't feel bad. We've always said we're the best kept secret, and I don't know why that is, but I'm excited, to share it with you guys, and then of course, it's a snowball effect, hopefully, and eventually more and more will be aware, especially now that anybody can represent a victim on an application, so it's really opened it up.
Nice. And I apologize I had a couple questions. One, and I understand maybe the public policy reason if the answer is no, but are there any like burial or funeral expenses for people who commit suicide as a result of their crimes, if a medical provider or a psychologist can attest to that?
We have been known to pay, yes, for funeral and burial for suicide victims. And of course, that's going to be a case-by-case basis. If we can verify that that was a result of one of our qualifying crimes, then we have been known to pay funeral and burial.
Okay, thank you.
And any other expenses that they might qualify for as well.
Okay. The theme I'm sensing is when in doubt, apply.
Yes, absolutely.
Another question, and I did have to, I was distracted there for a minute, but in case you covered this, but is there reimbursement for advocates who help people with these applications?
No.
Okay.
The only time CalVCB can pay somebody assisting a victim is if they are an attorney. Advocates assisting are not eligible for any kind of compensation through our program.
Oh, okay. And what does the attorney reimbursement look like?
It is 10, I think it's 10% or $500. I'd have to look that up if you
Like
shoot me a
10%
separate
of the
email
total
or
claim amount? So if
right
a
of the what we
tribal,
pay out.
okay, so if the tribal court advocate, for example, wants to file a claim and the tribal attorney as the court is assisting, that person can include that reimbursement or that amount also.
Yes, they would just on the application that section 6,
Mhm.
they would fill out as the representative / attorney for the victim, and then there's other documentation that's required. I think they have to submit a oh gosh, I haven't seen one in so long, but it's a sheet showing what kind of time was involved and how they assisted the claimant.
Okay, that's all I have, and thanks again, Cindy.
Oh, you're so welcome. Any other questions from anybody?
This is Cynthia Bochelle. And Cindy, wow, thank you so much. There's so much information you gave us today. It's really super helpful. So I wanted to thank you for that.
Oh, you're welcome. Yeah.
Go ahead.
Oh, I'm just going to add it is a lot of information. And so I don't want anybody to ever feel like, sorry if you covered this or, you're asking a question more than once. Like I said, there are things that I still come across to go, oh my gosh, did I know that we did that? Or and I must have known it one time and forgot because it is a lot. And that's what makes me so excited to work for this agency and to be able to carry this message to everybody because it's not a one-stop shop, but it certainly is a resource that covers a lot of areas for you. So I'm glad that you guys were able to take the time to learn more about it.
You and I previously had a conversation where you explained the difference to me between assisting a person with submitting an application and the difference between that and being a representative of a person. And I wondered if you could just briefly kind of explain the difference, because I think for me, when you explained that, it was really it was good information to know, and it's pretty significant.
Sure. And that's going to be modules that I'm putting together for the online portal. Goes into depth on it as well. And so a lot of times, I know as advocates, you guys are spread really thin and you can't represent every single victim that you come in contact with. So you can either just assist them with filling out the application, and you wouldn't fill out that section 6 on the application, which is ask for the representative information. You can help them fill out everything and then just not complete that, send it in for them. And if there's any communication that we have, we're going to reach out directly to the victim or the applicant, which would be a parent or adult in the case of minors. If you want to assist them, you would fill out that section 6, and it just asks for your name, contact information. You're going to sign and date it. And then that way, when we have questions about the application, most likely we're going to reach out to you first before we reach out to the victim. Let's say we need more crime documentation, or we're missing the documentation altogether, or we're unable to reach the claimant. We're going to reach out to you, or like I mentioned before, if we have an issue with eligibility, and we just looking for more information to help us substantiate the crime, we're going to reach out to you first. But then having said that, because you are so busy, don't hesitate ever to say, hey, you know, can you reach out to the claimant directly? We're certainly happy to do that. And if we can't reach you, we would do that anyway. But by representing the victim and their family members on the application, it's just more like the conduit between our program and the victim. So you're going to help them with the application. You're going to help them get their all their documentation together. And anytime there's a change in address or phone number, you're going to let us know that. And it's just basically helping us gather information and being the spokesperson on behalf of the victim. If a victim's filed an application and you're now in contact with them, you can always be added as a representative. There's a form on our website for you to do that. But it doesn't, again, have to be that formal. It can be via an email. The claimant emails you and said, yes, I'd like you to represent me and ask any questions or getting any information on my application. Here's my application ID number. You forward that email to me. I put a note in our system, and you're now basically their representative. So it's just assisting them with our program. And the other thing with representing is you can call in anytime and ask where are you in the status of the application? Has eligibility been allowed? Did you get this bill? Was this bill paid? How much do they have left in the way of benefits? Have they exhausted their mental health? Any questions whatsoever about the application as a representative, you would be able to call in and find out.
Thank you for explaining that.
Sure, of course. I was just looking at the chat.
Oh, sorry.
Oh, go ahead. No, go ahead.
I'm like pacing around. I had a quick question. If you've seen any, or if it's too soon to tell, but have you seen any increase or decrease in application filings during this time when people are sheltering in place and the like? Or any different kind of crimes? Or is there any trends that you're seeing at this time?
Yeah, not any that I've been made aware of, but I'm sure as time goes on, we'll learn. I have been curious about whether crime is decreased or increased, because probably outside, it's probably, I would say, decreased a little bit because people are, you know, shelter in place. But what I have heard, I haven't seen the numbers for our program specifically, but probably as you have heard, domestic violence cases have increased with people being home now 24/7 with each other, and then you add the element of the kids at home and people not being able to work, or they are working from home and the kids are doing studies from home, creates a lot of intensity and frustration. And so I know that there are cases that have increased in that respect, but I've not seen actual numbers with our program. And a lot of times we don't see that until the end of the quarter or the end of a fiscal year where they actually put those together. But I'm sure we will be doing studies on that. And that is information I usually will share when we give the different, you know, monthly webinars. Have you seen anything as far as trends?
Just anecdotally, we've heard the shelters are full, and I'm hoping the advocates can fill us in a little more thoroughly. But the one stat that keeps popping up is that DV is up 60%, and the shelters are full right now.
So is that a number in California or in the tribal communities, the 60%, or nationwide?
That is a good question. I don't have an answer. Maybe somebody else can speak to that.
Well, could probably say across the board would be my guess, the 60%. I know it's definitely increased dramatically, unfortunately. And probably with your within your community, a lot of you deal mostly with domestic violence and sexual assault, or the crimes that I talked about in the presentation, do you think will affect your community at one time or another? but is it mostly domestic violence, sexual assault that you're working with your victims?
This is Stephanie. I'm hoping that some of our tribal advocates will speak up. We are particularly Northern California Tribal Court Coalition. We're particularly focused on domestic violence, and that's kind of what a lot of our grant work is involved with. And a lot of the outreach for this event was through domestic violence task forces. So that's the lens that I'm looking through. But I would like to hear from others.
Okay, and while they're, hopefully a couple will respond, and while they're putting those thoughts together, one of the comments on the chat was explaining about the medical and mental health process again. I was talking about how the provider should bill the program directly, and once that application is filed with us, really super important to have the provider bill our program directly rather than billing the claimant and then the claimant expecting reimbursement, because we pay at a reduced rate. And so the provider agrees to accept that rate, we pay them, done. If the victim pays that expense and then submits it to us for reimbursement, they're only going to get reimbursed at that reduced rate, but yet the medical provider's charging them the 100% rate. So that's why we don't want them to pay that expense out of pocket. We want them to have the provider bill us directly. And that, as I mentioned before, is from once we get the application from the victim and they get that first letter from us, everything is at a reduced rate. But if the crime took place a year ago, 2 years ago, and they've been paying, let's say, mental health counseling all this time, they can submit those bills to us. Once we verify that those sessions were crime related, we reimburse that person at 100%. It's just once that application gets filed with us, that's when it starts the period that it's all at the reduced rate. And I know getting medical and mental health providers to accept our reduced rate could be challenging, but there are a lot of providers out there who do agree to work with our program. And I also mentioned that they cannot bill the claimant for the difference, or the victim. And sorry, it's confusing because I use the word victim, the word claimant, applicant, they're all potentially one and the same person. But providers cannot bill for the difference. And if they do, they're doing that outside of the law. And we want to know, if somebody's doing that. Sometimes they don't know they can do it, so it's just an honest mistake. But if you're aware of it, just make sure you let them know, or you let us know, that we can alert on our end that that's happening and shouldn't be happening. Any questions or comments from the advocates out there? I would love to hear from you. Are you, is everybody pretty much telecommuting, working from home?
Are you asking about at the Victim Compensation Board?
No, you guys, as all of your communities and your advocates, are you still reporting to the office, or? Looks like, yeah, Elizabeth said you guys are in the office. Social distancing, of course, yes. I know, I think we, I think we have about 250 employees or so at our agency, at least headquarters here in Sacramento. And there's probably 10 or 20 on a given day that are actually in the office. The rest of us are telecommuting. Yeah, it's definitely a whole new way of doing things, and it was, quite a transition. I think we started the middle of March, thereabouts, when they put the shelter in place, and getting, as you can imagine, getting everybody set up at home with laptops and the communication, our monitors, because we work with dual monitors. It was quite a challenge for our IT department, so huge kudos to them for getting everybody set up. But I think it's going to be probably down the road a new way of doing things too, to know that people can efficiently work from home. So it'll be interesting to see how things change. in that regard once the shelter in place is lifted, if more people will be working from home or if they'll just have everybody go back to the offices. I know me, for one, because I do a lot of traveling, I'm not in the office a whole lot. It would be really more efficient for me to continue to work from home and just go into the office occasionally as needed. I would love that, but it's different for everybody depending on what resources they have and what the needs are.
I think we can end this a little bit early, and thanks again, Cindy. Thanks, Cynthia, for connecting us and getting this information to us. And I think we'll be doing more training sessions through NCTCC, and anybody who wants to download, we encourage anybody who hasn't downloaded our app to do so. The link is in the chat box again, nctcc.org. And gosh, what is it, Jake?
Yeah, thank you for that. I'll make sure oh, thank you, Jake. He just posted it again. I'll make sure that that's
Okay.
circulated through our agency as well.
Great. And please download it. If you want any hands-on training or Zoom training at this point, any of the advocates that aren't familiar with the app and want to familiarize themselves with it, anytime that you're working with a victim, we hope that you can have them download it and have the information available, and give us any feedback that you want. It took us over a year to develop this with our friends at Shuffle Labs and NIJC. So, and an advisory committee of about 10 tribal advocates, some of whom are on the line right now. So thank you, everybody who made it possible. And please just go ahead, you can download it through the Apple Store or Google Play, depending on your device. And hoping it's pretty intuitive about the information that is available on the app. And we will be doing some trainings on that. If you want individualized trainings, walkthroughs, examples, please let us know.
Well, that is super exciting that you got that rolled out.
Yeah.
Sorry.
Yeah. Thank you, Cal. No. Thank you, Cal. Oh, yes, for the funding. Okay, everybody, if there's nothing else, we will say goodbye and hope everybody stays safe and staying out there and informed, and that we're all in an even better place to help those that we serve. Bye, everybody.
Thank you, and have a great rest of the week.
You too.
Thank
Thanks,
you.
Anthony.
Bye-bye.
Bye.